put behind you the late night parties and at the bar when we're here. And I'm Stuart Dresner. I'm Chief Executive of Privacy Laws and Business, and I've got the honour of running this session, chairing this session actually, and we have a double act with my colleague Laura Linkomis here. And together we run the Privacy Laws and Business set of services, and you'll see here, and this is a session on data breach, and we will go into that in detail, and I've got to spend no more than, all right. So we are most known for our international publication, which is now, we've had 30 years, 31 years actually now. We now cover 121 countries, and that's why we know what's going on in the world of data protection. Also, we cover all sorts of issues, as you see, for Blowout. Even the December issue, we were dealing with data breach in Australia. We've dealt with this in China, Japan, and so on. We also have a United Kingdom edition, which is just on the United Kingdom, and that started in the year 2000. They're both available paper, a lot of people, and electronic versions as well. We have round tables, and we have flyers there, which we discuss. Practical, it's privacy laws and business. So with the impact, we work not only on laws, on the impact on business, and indeed public sector and charities as well. And they're round table things, and this is our conference. This year it's our 31st annual conference in Cambridge. Smaller than this, a middle-sized conference, and we get people from about 25 different countries together, regulators, companies, law firms, academics, and consumer organizations. So it's a very wide-ranging group. Now, in terms of, and these are some of the themes we're covering this year, and if you share with us your personal data, we will use it only for telling you about data protection law, so you're very safe there, and we know our responsibilities, and you can unsubscribe at any time. So that's me. Now, data breach is very important, and we, in fact, 10 years ago, did a survey of 21 countries, national authorities. What do they want in terms of data breach? Did they want updating national laws, or do they see some amendment of the directive? Well, in fact, many favoured consistency across Europe, and many of the 21 national authorities favoured getting together and having a European rule, and that's exactly what we've got now. The GDPR, it is now, we no longer have there are separate national implementation, but there'll be now one regulation across Europe with a very important and strengthened data breach provision. And indeed, the OECD has been working on this as well. Very important publication, which was published last October, promoting comparability in personal data breach notification reporting. So that's available from the OECD. I've got with me the regulation, because I haven't learned every word by memory of the EU regulation, so we have it here in case we need to refer to it. Now coming on to the panel, Laura Linkomis is editor of the publications. Dina Kampouraki will speak first when she comes out, and she is originally from Crete, yes, and works at the EDPS, European Data Protection Supervisor's Office, and they have a team from all over the European Union, and I'm glad that Crete has got a mention there, is represented there. And Erik Valgaeren, Erik will speak next. Right here. Yes, you're there with the law firm Stibbe. How do I pronounce that exactly?
Yes.
Yes?
There's
Okay, sure.
possibilities, but you picked a good one.
Oh, okay. And Marc Vael from Esco, Marc at the corner. Now, he has spoken at our conference in Cambridge. He's been there, he knows about it. And you have several hats, actually. We're now with a company. We've also done data protection audits, both at national Belgian level and with the Flemish Data Protection Authority. Oliver Vettermann, yes, yeah, academic. So, but we've discussed together, so it's not going to be too academic. We have very practical, so academic in a good way. We've got a very interesting research project which we're going to hear about personal data when it gets lost and how it's lost and found, in fact, and reported. So we're going to find about that. And Lorena Marciano from Cisco, Data Protection Officer, and she will tell us about her corporate experience. So I'm going to stop talking, because I've reached exactly 5 minutes, and hand over to our first speaker, who is Dina. is being, Dina here is your controller.
Ah, I will use this one. Okay. Okay. Hello, good morning to everybody. My name is Dina Kampouraki, and I'm an IT auditor, and I work for the EDPS, the IT policy unit. Today we are here to talk about data breach, a very important aspect of the GDPR. In the GDPR, there are two articles, 33 and 34, that explain how the controller should react to a data breach. Also, Article 29 Working Party have recently drafted some guidelines on notification procedures that controllers should follow about data breach, and they will soon publish the latest, the final draft in February. Now, why this now? Why is data breach important? The main purpose is to protect the fundamental rights and freedoms of the individuals. A data breach can create several negative effects to people. It can produce physical, material, or non-material damage. Loss of control over my data, limitation of my rights, discrimination, identity theft, or fraud are some of the many listed things that a data breach can create to a human being. Now, what is a personal data breach? Under the GDPR, there are two articles. There is a specific definition in Article 4, Recital 12, a breach of security leading to the accidental, unlawful destruction, loss, alteration, unauthorized disclosure, or access to personal data transmitted, stored, or otherwise processed. In other words, if I am a controller and the data I'm processing, let's say, for example, that I'm a marketing company and I process customer records with identification data, financial data, credit data, they have suddenly become unavailable because I have a power failure in my computer room, or I have a ransomware, or they no longer exist because somebody destroyed the files accidentally or not. I have a physical event of disaster in my computer center and a parallel or simultaneous loss of my backups. Or they have been accessed by an authorized person, an attacker who gained access to financial information of my customer, or they have been sent to a wrong recipient by mistake, for example. All of the above that I haven't authorized constitute a data breach. A data breach, so, is an information security breach. So it should be clear that a personal data breach is a type of security event. The Article 29 Working Party published an opinion in 2014 that explained that breaches can be categorized according to the three well-known security principles. Confidentiality breach, where there is unauthorized or accidental disclosure or access to personal data. And integrity breach, when there is an unauthorized or accidental alteration of personal data. And availability breach, where there is an accidental or unauthorized loss or access of personal data. Now, you can see here a step-by-step duty perspective for the controller. Security and accountability matters most for controllers when protecting personal data. The controller has to apply the adequate security measures to protect the data processing. He can then eliminate the possibility of having a data breach, and where it unfortunately happens, he has to know exactly how to react to correct the negative effects. Another duty of the controller is when having a data breach, he has to measure whether there is a risk to the persons and how big that is. Then he has to notify the competent authority, and if that risk is rather high, he has also to notify the affected individuals. For security, we say always it's very important to be proactive. So we need a very good established incident management procedure, which has to be defined in the context now of a data breach, including the obligation for the controllers under the GDPR. It is critical to have a very good overall security program, technical and organizational measures to detect and tackle a data breach, training awareness during and among the staff, and a very good documented procedure with the ability to have prompt notification to the stakeholders, which, if we have a data breach, to promptly notify the DPO, the IT security, the management, etc., to know how to measure the risk, and to notify, of course, the controllers and, when applicable, the data subjects. Now, in the case of a personal data breach, when this results in a risk to the persons, the controller has to notify the competent authority. The information that the controller has to notify is about what happened, the nature of the breach, who was affected, data categories and data subjects, how he is affected, consequences of the breach, how he is tackling the issue, and, of course, the contact details of the data protection officer. And this, he has to do it in 72 hours after he becomes aware. Now, a critical question is the moment where the clock starts, the 72 hours, the moment the controller becomes aware that a personal breach took place. This moment is when he has certainty that a security breach took place, and the certainty is a proof that personal data have been compromised, for example. This depends on the circumstances of the specific breach. In some cases, it can be clear that has been a breach. In others, it may not be clear. When it's not clear, it may take some time to establish the facts. So it's important that, that when an incident happens, the controller shall promptly investigate if a data breach took place, so an internal process is needed for that purpose. Let's say an example now. A controller detects a possible intrusion in its network. He then checks the system to establish whether personal data held on that system have been compromised, and confirms that this is the case. This is a clear proof and a clear evidence of a personal data breach. So this is the moment when the controller becomes aware. In case now of a loss of a USB stick with unencrypted data, the controller may not be sure whether a data breach took place. However, as in that case, there is a reasonable degree of certainty that an availability breach has occurred, the controller would become aware the moment he realized that the USB stick was lost. In case the data breach has occurred in the site of a processor, for example, because we have our data in a cloud computer environment in a processor site, he shall be able, in the same way, to recognize the data breach and notify the processor, notify the controller as soon as possible. Under the Gdpr, the controller has the overall responsibility for the protection of personal data, while the processor has the important role to support the controller to that purpose and to his obligations. The controller shall have specific arrangements, contract, or other legal act with the processor which oblige them to report immediately a security breach or personal data breach. In fact, when a processor becomes aware, he shall notify the controller without undue delay. The controller is also aware when the processor informs of the breach. Article 29 recommends that the processor shall notify promptly the controller on a data breach with further information provided in phases. So when he initially detects that something happened, he shall immediately inform him and provide more information later on, but the controller, he will then be able to notify the competent authority, the supervisory authority, within the time frame of the 72 hours. Now, in cases where joint controllers are involved, contractual arrangements shall clear who will be the lead in a case of a personal data breach. When the assessment of a data breach concludes that there is a high risk to the rights and freedoms of individuals, the controller has to notify the individuals as well and without undue delay, which means as soon as possible. The main objective of this is to help the individuals to protect themselves. The controller has to notify what happened that might affect them, the nature of the breach, the data protection officer, the likely consequences for them, and the possible measures the controller took and what they can do also to protect themselves. When assessing the risks, there are some factors the controller needs to consider and has to do with two things, likelihood and severity.
Dina, excuse me, I have 1 more minute, unfortunately.
Okay.
Unfortunately, I have 1 more minute.
Okay.
I'm trying to keep as strict as possible. I'm trying to be Swiss in my timekeeping.
Okay, I will make it fast.
And then you will have, perhaps, we'll have time for questions at the end, if everyone is very disciplined.
I have 1 minute.
Okay.
Thank you. When assessing the risk, there are some factors the controller needs to take into account, likelihood and severity. The assessment of the risk is different than the one of the DPIA, of the Data Privacy Protection Impact Assessment. The first one refers to something that might happen. It's a hypothetical assessment. The other one, the second one, is something that really happened and we really have something to assess. Important factors to measure the level of risk are related with the type of the breach and the context. Other important factors are the nature of the data, the sensitivity, the volume, the ease of identification, the special characteristics, and the number of affected individuals. The controller should consider a combination, to make a combination of all the above. He should consider to produce a matrix with possible cases of data breach in his environment and have an assessment already that will guide him through the process. So nowadays we hear every day on cybercrime events, vulnerabilities in hardware and software that can create uncertainty for all in the field of security. Organizations, controllers, must keep an eye on the many new and constantly evolving threats and address them threats in the incident response plan. Having been working now in the European Data Protection Supervisory, for us it is very important to provide the right guidelines to the controllers to meet the requirements under the Gdpr. Thank you.
Thank you, and sorry, it's rather brutal timekeeping, but we have a large panel and very short time. And also, if we manage to get through all our set pieces, then we will have more time for questions with the audience. So now handing over to Erik, Valgaeren, Stibbe, and an experienced lawyer, and you can give us insights from your legal practice.
Thank you, Steward. If it's okay, I just prefer to remain seated because then I can have all my digital assets around me and assist me both in terms of content and timekeeping. As Steward said, I am a practitioner based here in Brussels. Been involved in data protection and technology law for more than 20 years. We have assisted a number of clients in a broad variety of data breach matters. And obviously most of those matters were pre-GDPR. Now we are entering a new era with new obligations, and a lot of companies have to get used to the idea that there are actual obligations surrounding a data breach. Because pre-GDPR, the obligations that existed were primarily obligations that came, for example, from a financial regulatory dimension, for example, companies listed on the stock exchange, or in the telecoms industry where there were certain reporting obligations to the regulator. But now we get a different ballgame. And what I wanted to do in a few minutes allocated to me was to give a brief overview of the questions that we get and the type of actions we take towards clients, or how we talk to clients about what is happening. And I think Dina already outlined the legal arena of obligations, but this is just a very brief summary to identify what exists under GDPR in terms of obligations. So we have 3 different obligations in terms of notification. We have 2 that are imposed on the data controller, one towards the DPA and one towards the data subjects. And then we have one obligation, direct obligation on the processors. which is interesting because now the GDPR itself is a source of obligation for a processor to report data breaches, and his reporting obligation is towards the data controller, who then, in a system of a cascade, needs to take appropriate steps in accordance with his obligations. And as I've outlined, there are different criteria, and we get questions on those as well. One of the questions we get is, for example, when is there a risk? We are very happy with the guidance provided by the Article 29 Working Party on this. Dina mentioned this guidance. From a practical perspective, what is important is that if you look at the identification of the type of damage that is relevant to assess the presence of a risk, from a legal perspective, it's basically any type of damage, because once you have physical, material or non-material, for me they could just have written any damage, because I don't see any damage which would not qualify under any of these three categories. What is also important in this definition is the word can. So this means that the threat, the potentiality of a damage by itself is already enough to trigger the obligation, which is also important in terms of how you set up your systems to assess possible threats and triggers for an obligation to report. I gave some examples of what in certain cases we found sufficient or through the guidance of Article 29 Working Party is sufficient to trigger this obligation. For example, anything that deals with payment card or bank account fraud would amount to a relevant damage or threat of damage to trigger the reporting obligation. Identity thefts and also tampering, for example, with car data, because this could endanger the physical integrity of the people in the car. Same goes for the concept of high risk, which is also something on which we have received a lot of questions, like what is then high risk? There is no real definition in GDPR, and again, the guidance of the Article 29 Working Party is useful. They have included about 10 criteria in their guidelines, which either go to type or scale of processing, the type of the data or the type of the data subjects involved, or to the purpose of the processing. So we have a multi-layered kind of matrix there of criteria that can lead to the presence of a high risk. Again, I've given some examples of where there would be high risk. For example, the kind of breach of trade union membership information, where a large set of these data was sent to the wrong people, and these are obviously sensitive data under GDPR, so in that case there would be a high risk. Lots of medical data of mentally ill patients, where you have both sensitive data and a vulnerable category of data subjects, and also breaches in data processed by camera systems to recognize license plates of cars. For example, in a road charging system, as we have it in Belgium and other countries, there are sometimes problems with security of these systems. Next, I wanted to briefly present an overview of practical points of attention in line with the respective GDPR requirements. So again, a first requirement is that there has to be a timeline respected, so that 72 hours, as Dina said, this is as of the moment that the controller or the processor becomes aware, especially the controller, because the processor has no specific time limitation stuck to its obligation. But this means that if you are a controller, you need to be able to prove that you acted within 72 hours. So this means that you need to have a clear response plan that allows you to act that expediently. It also means that you have to be able to track and trace the steps that were taken once you identify a problem. And you need to have people that are not only aware of the obligations, but also properly trained in executing them. This is often underestimated by companies, because they will have paper procedures in place, but they would not necessarily have the people trained to act in accordance with the plan. And then obviously even the best plan will not be very effective if the people are not trained to perform it. The awareness test, so a reasonable degree of certainty that there is a problem. This also means that you should not, or you will not be able to invoke the fact that you needed further investigation to find out details. you need to act once the potentiality of the threat is sufficiently clear. The need for documentation is a very important part of what companies need to do, and I will just refer to the incident logging, which I think is going to be a crucial cornerstone in the way companies will actually prove that they were documenting what happened, because obviously everything will be auditable in the next stage. And this has been hinted at by Dina as well, it's important that when, as a controller, you set up processes internally, that you use your contract with your data processor to make sure that the data processor follows a similar process, allowing for what I would call a smart back-to-back system. Meaning, obviously, that sometimes you may need to impose stricter requirements on the processor so that as a controller, when you receive input from the processor, you can still act timely towards the outside world, DPA or data subject. That's what I would call smart back-to-back contracting between a processor and a controller. This is then towards the data subjects, which is the second obligation, where I want to point out the fact that it's important to deal also with the language aspect. You will see, and that's the second point in the requirement, notification has to take place in clear and plain language. In a country like Belgium, for example, we already have 3 official languages, being Flemish, French, and German. In addition, a lot of the commercial communications are conducted in English. So you need to be aware as a data controller that there may be a need to communicate in different languages to different target groups. So that's important to keep in mind as well. To have a uni-language communication string, just English, for example, would not be sufficiently, or would not be sufficient here in this country. And also to have dedicated messages, which I think should be clear. I'll move on to the next point, which is content of the notification. Again, if a data controller decides on the content of what goes in the notification, this has to be done by trained personnel. The DPO, if there is one, obviously will be involved, will need to be involved. If there is no DPO, then obviously the company is well advised to make sure that they get external views on how a communication or notification should be drafted, and it's obviously better that they do that even before an incident occurs, so that at least they have some kind of generic language to be using in an instance, and then they can, at the time of an actual incident, have that validated. And also, they should make sure that they include clear information about all the measures that were taken subsequent to the breach. I will reserve the last kind of points on this slide for further discussions, and I will just end with one conclusion at this stage, preliminary conclusion, based on the practice, is that setting up a data breach notification process is at this stage still underestimated by companies. Companies are in general still wrestling with the concepts in GDPR. We try and advise them as well as we can on how to deal, for example, with notification processes. But what we see is that a lot of the companies have no clue as to how they should implement that in their own structures and processes. So I think there is still a lot of work required here, and I think there's also work for technical people who are able to work with us lawyers in order to identify the right processes and procedures. And I'm sure that in a subsequent discussion, the one that will be managed by Lorena, a number of these things will become very clear. Thank you very much.
Thank you very much. And you just saved yourself from incredible self-discipline. I had the 10 minutes. I'm just about to ring the bell when I could detect that you were about to enter your last minute. So I will ring the bell after
I felt you coming, Steward.
Yeah, that's right. Very good. So, and now we are, so thank you for that self-discipline, very interesting. I've been taking lots of notes, a lot of good points coming out here. And now from Marc, who's going to speak next, he has not only, he's speaking from his company perspective now, but he has a lot of experience in consultancy also working from the perspective of, as I said, the National Belgian Authority and the Flemish Belgian Authority. But fortunately for us, he's going to speak in English. Well, fortunately for some of us anyway. For others, it would be good if we spoke in Dutch, I suppose, or French. But anyway, the language of the conference is English, so we'll wait for you.
Thanks, Steward. Hello, everybody. My name is Marc Vael. I'm currently CISO at the company, but I have 25 years of experience, of which 20 years in IT auditing as DPO for a number of companies, and I've been in practice handling some privacy incidents, of which 3 large ones, which were never published in the media, so we dodged the bullet there. But it was interesting to see how they handled it, and I think that's my experience I want to share with you. First of all is, a lot of people think that breaches happen by hackers, and that's totally fake. Half of them are done by external people, half of them are done by internal people. And it's sometimes done by mistake. They make mistakes, human error on the inside, and they, by coincidence or by mistake, launch a lot of personal data in the open on the internet. So I think the first problem is that a lot of people think it's only from the outside that people make mistakes, but I want to point out that it's both. It's internal and external. If you look at the methods that they are used to do data breaches, from the outside, of course, it's through social engineering or hacking. That's one of the most known versions, but also malware can be inserted in systems to capture personal data or sensitive data. And of course, physical theft, let's not forget that it's not only on computers that data is sitting, but also on paper, in cupboards, in archives, which are sometimes thrown just in the dumpster bin. So it's very easy for a person to go into the dumpster bin, what they call dumpster diving, catch all the data, medical information, salary information, and just use that. So let us not forget the physical paper theft as well. On the insider, again, social engineering, people just change information. They're a service desk, so they help customers, or they think it's a customer, but also physical theft, and again, privilege abuses. A lot of people have maybe too much access to information that they shouldn't have. And from personal data perspective, I presume that most of you know that HR departments are quite known for their kind of, fear of that salaries will leak, but there's so much more personal data out there, customer data in all these systems, and that's an important element. Now, if it goes wrong, if you have a data breach, well, a lot of things can happen, but most of the important element, of course, is to keep control. And in my personal experience, I have a brain teaser for you, is that most people think that they can handle it because the data breach happens in their organization. Now that's a challenge, and Lorena will talk about that, but also the fact that this can happen at the supplier. We outsource a lot of our transactions, our processes to external parties. You know, cloud providers, HR companies who calculate salaries or help calculate salaries for us. And all these third parties who help an organization, the breach can happen there. Now, I'll put another brain teaser for you. Most of these companies will outsource further to other third parties. And that's very interesting, because then it becomes interesting. So you can have a contract with a third party who is ISO certified, follows all the rules, have all their concerns. But if they, in their turn, outsource to another third party who can't even write the word privacy, you have a problem. My main experience with handling an internal incident versus an incident that happened at a supplier is, on the inside, you can have control, you can bring the people together, you can easily find what's going on. When third parties are involved, communication becomes vital, and you're really dependent on how well this third party will help you getting your information, getting really sense of what's happening. If you're lucky, it goes really fast. If you're not so lucky, you hit a brick wall. And that's a big difference. So please think also of the outsourcer and the subcontractor of the subcontractor of the subcontractor. Because sometimes you might in for big surprises which are not in the contract or which are, let's say, gray areas. From a breach point of view, I recommend always to have this kind of simple checklist with 9 steps, and I think the most important step is not in the beginning where you do all the analysis and the prevention, but also the containment, eradication, and recovery. But I think the most important element that often is forgotten in a formal manner is the lessons learned, the post-incident review. Now, what I expect from GDPR and what I expect from more organizations is that organizations will be able, that there will be a mechanism in place to share these lessons learned amongst peers in a secure, confidential manner. And that leads me to a number of points that are interesting. If you look at the prioritization, there's a difference in a number of categories. I'm a technical person from background, economist, so I look at processes. And there are a classification in terms of what is the sensitivity, what is the incident prioritization of the incident. Not all incidents are equal. And I know some people will raise alarms, but you have to be careful how you raise the alarm. We've seen the Hawaii incident where people got a message saying, you know, forget it, there's a missile coming, you're all dead in 30 minutes, basically. Then we're like, oops, failure. I mean, it can be easily, if you do cry wolf too many times, people will not believe you anymore. So we have a moral obligation to really define very well what is a high risk and what's worth escalating. Because otherwise we become cry wolf people and we will lose all credibility. I think that's a very core message I have to give. And also, if I look at how companies use risk scales, Erik and Dina mentioned the high risk, I don't find that back in a lot of risk scales. A lot of risk scales are negligible, acceptable, average, important, critical. There's no high. What's high? Critical? Important? Where is it? I think it's key that in an organization, you look at what's the enterprise risk scale and define where the high is, at what point high is high. And it's not necessarily low, medium, high. That's for dummies. Most have more complex risk scales. If you want to find sources, I can refer to COSO, which is from the United Nations. They have an enterprise risk model, COSO ERM. Look it up on the internet, it's free. In US, you have NIST, who has a very clear risk methodology, really in practice, NIST, N-I-S-T, SP800, and you type in risk model and you'll find it for security and privacy. But also in Europe, ENISA is doing brilliant work on the risk model. Now, of course, I think the most important element is always keep calm and, you know, act sensibly. Don't look like a headless chicken. And I have also a message for you is that resources are scarce. We are scarce in terms of people. You know that there's already a vague for DPOs. But you have to find a way to do the good, cheap, and fast. And there's always this, only pick two, good and cheap won't be fast and good won't be cheap, and cheap and fast won't be good. Take whatever you want, but you can't have everything. So you have to pick your battles, especially in privacy. And it's most important that you have a good inventory, then do the good risk equation, but from a data breach perspective, also make sure you evaluate it correctly. And know that there's always a way in. From the inside or the outside, can be a contractor, can be a student, can be an interim person, can be a stagiaire who can just come in. And you know, corporate espionage is a fact. It's a reality. So be aware of that. Now, my final comments to close is, what about sensitive and personal data exchange between a controller process and the DPA? I mean, how secure is that? If that's not secure, what is the risk? And also, I wonder if the soft target will become the DPAs. The DPAs authorities could become the soft target for hackers, because if they got a lot of information on where the vulnerabilities are, what real hackings is, this could be valuable for hackers as well. So I wonder if they have the right ammunition as DPA, and I think we as an organization have to control our information. If we share it with a DPA, we have to be sure that the information remains as secure as possible at the DPA. That would be, that's opening a can of worms, I know, but we have to ask that question because they don't always have the right means technically to protect themselves. And finally, a final comment is careful about contract changes. I mean, I hear a lot of people saying that you have to change your contract in order to include data breach and how you do this. Be careful, because I've seen in practice that companies use this as an excuse to break open the contract and, of course, increase the fees. Thank you very much.
very interesting project which you'll tell us about tracking data which has been lost.
I hope it will be interesting afterwards because it's mainly on the German law.
But the
I guess.
principles are interesting.
So, just to skip the not interesting part. It was kind of too fast. So, in the beginning, I would like to introduce you our project, which is called Project ID. It's kind of difficult because it is kind of German abbreviation. In English, it would be the effective information after an identity theft. So the main purpose is that we want to give the control over the personal data back to the data subject. So the intervenability of data could be given back to the data, and it is kind of the data subject can handle the data breach more or better. Oh, okay. Sorry for that. Just pull. Yeah. Sorry. So our scope of the research is about the public data sets or databases like Pastebin, Twitter, or shared links and social networks, and some kind of shared links in Dropbox and so on, where you can find the digital identities or data about digital identities, like credentials when you get to log in, like password, email address, or maybe furthermore credit card data and so on. So our tool wants to scrape the data or scan the public data or public available data, and then inform the controller or notify the controller that there is data found that leads to the controller or the processor, and then gives the opportunity to the controller to notify the supervisory authority and the data subject. So the controller also knows how huge the data breach was, and furthermore more information about it. So you can barely see that this goes hand in hand with Article 34 and 33 also of the GDPR, and maybe some risk could be decreased. And also F42, so maybe it could be more cheap, but we don't know already yet, because the project started in March last year, so it's at the very beginning. Sorry for that. So to show you how it will work, I prepared something which you have already seen. On the right side, you can see the data of the data subject, which goes to the controller, or the processor, which is, as you know, connected to the controller. So then, data breach happens, and the data will be lost by hackers or maybe a man-in-the-middle attack. So data is gained by them, and later on, shared in public databases. Then, Project ID comes into this whole process and is going to scan this, and later, as I said, it does notify the controller, and the controller has the opportunity to inform or to notify the data subject more, or in a kind of better way, because it can the controller can say where the data has found, what's in the database, and furthermore information about that, so it can be more concrete. At least I want to give you a briefly look what we were working on in the last month, and what have been the most or the big problems in our German law system, because it is kind of old-fashioned. So in public law, what is mainly constitutional law, and my side of the story, I had to look furthermore into these kind of fundamental rights and human rights of natural persons, because there's quite a big problem, because there's no digital identity definition, and we don't already know what it is, so we had to find a definition, and then connect it to the definition of the analog identity or the personal right, which is defined by, or was defined by the Federal Constitutional Law, Federal Constitutional Court, sorry. So we had to digitalize the law or the definition. And then there had already been some kind of problem because there is already, as I said, also no definition or explaining in the law what data is. Is it a thing I can touch? Is it something I have rights on because it's my property? There is nothing. At least there is data protection law, but sorry. I hope it's on the video. Yeah, there have been all these kind of problems. And we had also the balance tests with the interests and rights of the controller, because they are also in some way protected by the fundamental rights. But the big conclusion is that there is a broad shelter, and that is ruled in concrete by the GDPR. Then we have the private law kind of way to look at this stuff, because there's also another problem in copyright law. So we had to analyze if the digital identity is at least a database which is protected by copyright law. And that's also kind of old-fashioned, because there isn't such an analysis or something similar which explains how to handle that. So it's basically groundwork we had to explain very, very much in the last month. So it also seems outdated, and we have to work a lot of on that. And best for last, data protection law, which is or has kind of a starring role in this whole process. So we had a lot of scientific research about the whole framework, which we want to introduce, and we had to check if there's a kind of, I don't know. So our scientific research is not, or has not to be, let me look for that. That happens when the blackout comes. Exceptions, that's the word I was searching for. We had to look if there's an exception for our scientific research team, and there is, because of there's Article 89 and the Section 1 and 2 of the DPIA, which can handle that. And furthermore, my colleague Susan Gonczarowski, which you might know because of her talk on Wednesday, had to distinguish the different data sets and into their kind of risk level. So we have a kind of high risk when the data is illegal and it is personal. And the kind of opposite of the upside is when you have legal and anonymized data, because you can delete it or bring it back to the data subject. So at the moment, my colleague has to check if the digital identity is already well known in the terms of GDPR. But in the end, at least we can say the substance of the digital identity is protected, because at least it is personal data. And to come to end, I'm going to summarize what we are doing next. So we want to, or have to, analyze the current draft of our framework, which we had we received in December from the University of Bonn, and we have to do the whole DPIA process on that thing, and have to supervise at least the whole processing of our framework. And I am going to look further what is kind of the main point, or one of the main points of the project, to look and to analyze if there's an obligation of the German state, because there are at least, or is at least, an authority which is maybe known, you know, under the abbreviation of BSI, which is kind of responsible for the whole digital infrastructure in Germany and the security of the digital infrastructure. And I have to check if they have the competence or they are responsible for the whole thing. Thanks. Okay. That's all.
Thank you. And now we come to a very different, again, presentation. This is Lorena Marciano, Data Protection Officer at Cisco, a well-known large company. And so we get a more corporate perspective.
Yeah.
Lorena, thank you.
So I feel I have a bit of expectation because both Marc and Erik kind of called me out during their presentation. And so I hope I will live up to their expectation. But my idea today is just to take you to our own journey about how we built a data protection policy and procedure within Cisco. And I will start off with tell you why do we care. So Erik says a lot of companies underestimate the procedures in data breaches. I'll tell you why we don't. So if you Google us and Cisco and Trust Center on the same on Google, you will find our Trust Center. There it's where we publish every 6 months our annual report on data breaches. What it means that we go back to all our customers, all their security professionals, and we ask them, why should we care about having a solid security measures in place, and why we should care about then also have a very important data breach procedures, which, as Dina said, is fundamental to any privacy procedure, to any good privacy model within your company. Well, just a few of information. This all comes from our annual report. So that's all our own data I'm sharing with you today. Well, we only in the last 6 months, I think we already in the news, but many companies suffer from an enormous ransomware attack, which was in terms of loss for a company around $1 billion US. We do have an enormous amount of loss of physical theft. Now, luckily for a company at Cisco, we do encrypt our laptops, so it doesn't hurt so much for us if my laptop or my device are robbed at some point. We also see another thing that's quite remarkable is that every day a company of which we ask for information and for data, they told us that they receive about 200,000 attacks of malware per day. It's enormous. It means that the striking fact is that it can happen to any company. Because up of today, I think every company is digitalized transformation. I think we use a lot of data, we use a lot of cloud-based solution, and in that sense, we are at risk because we do have a lot of data out there somewhere that needs to be protected. Now, we went a bit farther in our study. We made a correlation. We tried to make a correlation by having a very good privacy maturity model within a company and the risk of being attacked. And so we asked 3,000 of our customers if there was a correlation. And what came back, interestingly enough, is the companies that are not very mature from a privacy perspective are more likely to have a cyber attack with around of an amount of $500,000. While the ones that were much more mature from a privacy perspective were at risk only on the 39%. That being said, we do think it's quite important that you build a privacy mature model in your company, and having a very solid data protection incident response is quite important. More important than just complying with the law. It's really important just to protect the most valuable asset that we have today, which is indeed data and personal data remarkably. In terms of how it works, this is really how we work. Right, so this is our process. I try to simplify for all of you, but it starts really with the detection of something that it's not going well in the company. And how do we detect that? Well, through our security systems, but also by empowering our workforce to come to us and tell us there's something, I saw something it's off. An email, People, 78% of people in our organization usually click those phishing emails. Those people are the ones that need to report to us if something is wrong. Something came in and there is a problem that needs to be fixed. And so we do have a procedure for those people to come to us and let us know if they detected something on their laptop or on their databases, that it's off, it looks off. So most of the time that's how we rely also on detecting this, together with our security, of course, detection systems. And then there is the second piece, which is the most important, is when you do triage. What is triage? Well, you need to understand what happened. So it's the most important piece. And when you need to do the triage, the first question is always what has been exposed. Are we talking about financial data? Are we talking about data that are coming from our customers? And if so, how many of them are personal data? As you can see, we kind of define personal data in a very broader sense, because that's that's just the life we live in, right? So the definition of personal data is just expanding. And then, of course, we also ask ourselves, do we have an intellectual property that it's out there and we need to protect? And then we try to understand when that all first started. So when was the explosion coming up? And then how it was exposed? Is it coming from a phishing emails, or are we getting a malware attack somewhere else? Or as Marc says, is that an intentional error, or is that a human, not intentional error? And also, most importantly, again, who viewed the data? To the point of Oliver that says before, the data are taken and it can be exposed free on the internet. So that's also something that we need to understand. So when we do the triage, then we move to the second phase, to the other phases, which is really to understand if there are any data breach notification that needs to be triggered. In other words, are personal data exposed? And if so, are we falling within the notification requirements? And that's also when, again, this moves to a broader audience within the company. That's also another point that I want to make. This is not an effort for a security guy only. We cannot do that alone. It's an effort that goes up to the top of your board of directors in your company. It's for your legal department to participate. It's for your compliance function to participate. It's for the department that was ultimately attacked by the incidents. And that's where, in the second phase, that's where we gather together as a privacy office, legal team, security team to understand, okay, if that happens, what's next? So what's next for our security team is to go ahead and create a resilient process, because there is still business to go ahead, and therefore we need to allow for business continuity. We have a legal obligation. It's in Gdpr as well. Gdpr requires to be resilient, but it's also a requirement as a business company towards our customers to have an action plan to move further and to resolve the problem, but also how do we protect the data immediately and do we secure them, the one that are being exposed. Then there is the last part, which is the execution plan, which is for the privacy department and for the legal team is really to go ahead and notify the authorities, and for our security team to put in place the action plan that was decided. In terms of how do we carry out that second part of the analysis, those are some of the questions that we usually ask ourselves. One piece it's important, I will call out because it was told by Marc and Erik, is for us it's also very important to understand, to have a full picture of what are the requirements that we have with our customer when we are exposing, when something happens and some of our customers' data are exposed. And so it's quite important to have a back-to-back agreement, that's so for sure, but to be consistent. If you're in a position like Cisco is sometimes to be the processor, it's quite important that when you negotiate with your controller that you are consistent in saying, look, this is what I can give you, that's our policy, and that's what I want to be reflected in the contract. Why is that? Because if you start making exception, it will be very difficult to manage if something happens, and it gets lost, and it's confusing, so it's quite important to be strict. Also, when you negotiate from a processor side, and really to have a thoughtful discussion with your customer that is acting as a controller. In terms of other consideration that we do, now, another consideration that we do in terms of understanding when we need to notify the data subject, it's really how much we're exposing people and what's the harm that we're causing to them. I think I don't need to probably remind anyone the breaches that we had on the news, the Equifax breach, for example. One thing that we want to avoid, and we have in the situation where data being exposed, and then we ask more personal data to those people to then understand what data were lost. So that to say that it's quite important to have an understanding of what data do you have in your company, because if you know what you have, then you can also understand what you've lost and what the likely harm that you have caused outside. So data breach, as I said, it's an important element, but it's really, really important if you want to be a full privacy mature company, that you have a deep understanding of what you have, that you have a reason to have it, and if you don't, you just don't keep it. In terms of the classification, so Marc, you said that the low, medium, high, and critical is not enough. Well, I might disagree with you on this one. The reason why we identify those very simple, apparently, categorized is because this needs to be used to all people in your company. So the reason, the way we do the awareness campaign in our company is to make everybody aware of these escalation points when a data breach happens. The reason we try to simplify for them is because we want to make sure that they also are cooperative and understand what is really critical and needs to be protected. And so we try to simplify, and we made the law, which is a recurring loss incidents, and then, yeah, and I'm done, that's good. And then medium, when there is a subset of more data, but still it's not impacting personal data. It becomes really high in our company when it's becoming to impact our personal data. And then that's where we go to the 10 factor that Erik was mentioning earlier, understanding, what the type of data subject, what was the processing carry out, and so forth. So I'm going to go just to the last slide. We truly believe that a breach is not usually a disaster. The way you handle it, it really can be. So don't underestimate it. That will be my recommendation.
Thank you. Good morning, everybody. My name is Laura Linkomies. I am editor of Privacy Laws and Business Reports. I've stepped in to be a moderator for this panel because, unfortunately, Christos Velasco couldn't make it. So it was fascinating to hear about data breach from so many different perspectives. And before we open up questions to the floor, I'd like to ask just one question to our panelists, if I may. Dina very clearly explained to us how the requirement of 27 hours works, 72 hours works from becoming aware of the data breach. I'd just like to hear from others, do you think that works in the real world? And what do you understand being reasonable delay? Do you want to start, please, Marc?
From my practical experience, usually after 36 hours, people have a really good basic understanding of the 80% rule. So after 36 hours, people most of the time when the first kind of alarm hits, usually if they do a scramble and people from different groups, as was mentioned by many people here around the table, so it's not just one person, it's multiple disciplinary teams come together and they start communicating, figuring out what happens, and after 36 hours they usually have, I think, already done 3-4 meetings, and then they slowly get to the grip. So for me, 72 hours is a good view to have the basic understanding of what's happening. Not in full details, not with full report, but having an extent of what's going on, where it could potentially lie, and then of course further investigation is needed. But 36 hours is the average I've noticed.
Thank you. Dina, do you want to add something?
Like I said in my presentation, the moment that the controller established the fact that there was a security incident and a data breach, he has the obligation to notify the competent authority. However, I think and we believe that tackling the incident is most important at that time. So the Gdpr gives also the possibility to notify the competent authority in phases. That means that he can notify about the event without having the need to complete the whole information about the security incident and the data breach. And because at that moment, it's more critical to tackle the event and try to minimize the negative effects. And so I think 72 hours is enough. The moment he becomes aware, if he doesn't have the whole information packets to say to send information to the notification to the competent authority what happened, and later on, after he gathers more information, he is sure and he tackles the incident to provide more information.
Thank you. Oliver, what is your view on this?
Just copy what Dina said. I was constantly nodding because I would say the same thing. We have the possibility of the phases, what leads to the fact that the 72 hours have to, you should notify within this time scale the basic facts, what happened, what you can do, and what you don't have to do, and maybe that's all. And in the background, you can furthermore investigate what happened really, how big it is there furthermore I can do as a controller or processor, and so I think also that's it. Yeah.
Thank you. And Erik, your experience from the legal practice?
Thank you. Looks like we're all agreeing it should be 27 hours rather than 72, but I just wanted to add that it's just a best effort obligation. If there are complications, then the 72 hours are not valid. You just have to motivate why you were not able to report within 72 hours. But I think in most cases it would probably be possible to respect it and report something. So.
Thank you. And Lorena, are you able to notify in 72 hours in your company?
Well, we take it that we don't have any other choice, so of course we will notify within 72 hours. There are other experiences. It really depends how it came in. That really makes a difference. So if it was that report, was that phishing emails, or how that happened, it really makes a difference in our ability to be able to understand what happened. So I think that's a critical moment. But we technically, yes, we can notify within 72 hours.
Thank you. And questions from the floor, please. If you can mention your name and organization, please. Would you like to come here to speak to the microphone? Just short questions, please, and we can fit in more.
Good morning, everyone. I am Roger Salunge, PhD student, Erasmus Mundus, last JD. I have 2 questions. First, from a strictly legal perspective, is there any difference between a data incident and a data breach? And what are the legal implications of each? Maybe under EU law, in Gdpr or the 95 directive. And secondly, I know Article 34 says the data controller can be exonerated if he implemented appropriate technical measures to render the personal data unintelligible if it was breached. So my question, I'm kind of a little skeptical. What if I encrypt data, I'm a data controller, encrypt the data normally, and it is breached? Well, it's encrypted, so I don't see a need to report. And later, the hacker succeeds somehow to decrypt it. How does that exonerate me from liability because I had once encrypted it? Or is there a level of encryption under EU law which is regarded as maybe the standard, which if you attain that standard, the hacker succeeds to decrypt it, it now becomes a case of force majeure, and which exonerates me from liability? Thank you.
Thank you. So who would like to tackle this one?
So probably just tackle the incidents versus data breach. Sorry, that's fine. Yeah. Yes. So not every data incident is a data breach. So the incidents sometimes it can be something happened that you have compromised data, but they're not leading to a data breach under GDPR, which entails also the data breach which have been attacked a number of personal data that then triggers the notification requirement. So that's a bit of difference, but legally speaking, we always refer to data breach under GDPR. If someone wants to add something on that regard, and then for the... okay. And then I'll leave the encryption to Marc.
Thank you. Indeed, there is a difference. If you look in the GDPR, there's only one time the word incident management, and that's only in the security processing, where they say, okay, if you have things that go wrong technically, an incident does not necessarily lead to a breach, can be a hiccup. It's something, an incident in technical terms is a deviation from the normal standard operating procedures. So everything that's a standard operating procedure, including exceptions, That's normal operations. As soon as you deviate from that, you have an incident. An incident has to be investigated or not, depending on the scaling mechanism, low, medium, high, whatever. And then you have to determine. So the breach is really when you come to the conclusion within hopefully 72 hours, but usually after 36 hours, that you have something going on that is a breach. So that data is accessible for non-authorized people. I think that's the big difference. So if you look at the GDPR, always go to the authentic source, incident mentioned once, breach everywhere.
Any more questions? Yes, yes, please.
Concerning the question regarding encryption, if there is a data breach of an encrypted data that are encrypted with a very good algorithm and they cannot be decrypted at that moment of the loss, then it can be deemed that it's not a data breach. However, after 1 year, if the encryption algorithm is not that robust anymore, it can be decrypted, then it might be a case where there is a data breach and it has to be notified. So the controller has always to assess the available technology in the market. And so if he has lost encrypted data and this can be decrypted, then he has to notify that to the competent authority.
But maybe you could also say that the data breach happened, but the risk level is not that high. Because when you understand the term of personal data breach, like the DPIA is saying, of loss, alteration, unauthorized disclosure, it could be disclosed in the internet, but you can do something with it. But if the decryption level rises in a few years, it can happen.
I want to I'll kind of make a nuance to the encryption stuff. Yes, people do encrypt the devices, but if your laptop is in sleep mode without a password, it's open. So that's one thing. Secondly, yeah, you have different encryption algorithms. You have the easy ones and the very hard ones. So you have to be careful what type of encryption. So please ask what type of encryption is used. There are different encryption algorithms. Some are stronger than other ones, so be careful about that. And finally, yeah, it's not because indeed the encryption is able to be decrypted that it suddenly becomes something different. There's also have to be accessibility.
Thank you. We can fit in one very short question. Anybody? May I ask then something? I think, Erik, you mentioned this yesterday at our lunch. You were concerned about the security of the notifying to the authority. You had some concerns about sending potentially sensitive data to your authority about your breach.
I think in all fairness, this was a point raised by Marc. I think he also touched upon it in his presentation, and I think it's a very valid one. I mean, if you are so kind of concerned about security within the company and under the regulation, how do you deal with that in a relationship between a controller and a DPA when the controller notifies a breach and sends documents and information? But I think the point was raised by Marc, and I think it's a valid one.
Thank you. We have now run out of time, so I would like to thank all our presenters. This has been a very fascinating panel, and I'm sure they will be happy to take more questions over coffee. Thank you.